A new case was quietly filed in Charleston on May 21st, a case that would probably go unrecognized by the masses. It's a case filed by Inquiry Agency, LLC, against Baker Hostetler, LLP, and Jason DeCruz. Who's that, you ask? While many in the legal field may have heard of the legal giant Baker Hostetler, even this name doesn't signal big attention. But it's a case with the potential for big impact in a case we've been following. That's the conspiracy case filed by Mallory's mom, Renee Beach, who's represented by Mark Tinsley. This is Not in Vain with Cassidy O'Connell. Episode 3. A new case clears things up. Welcome. I've made 2 podcasts about it, and I promised to keep you updated. So today's podcast is that very update. Now, I was already working on one based on the first hearing since Judge Price was removed. His replacement, His Honor G.D. Morgan Jr., held this hearing and made some decisions on a couple of the motions that have been waiting for a long time to be decided. We're going to discuss that hearing and the decisions that came out of it in the next episode. But for now, we're going to have a peek at this new case, because I, for one, was a bit frustrated with one of Judge Morgan's decisions, and I think this new case will hopefully clear that up a bit. In the end, it could possibly lead to a settlement because the allegations in this new case pretty much dissolve any of defense's claims of innocence. I think the first order of business is identifying the plaintiff, Inquiry Agency. If you watched my first podcast in this series, you might remember this agency, but let's review them. Inquiry Agency is a private investigation agency in South Carolina, with the only agent listed on its website being Sarah Capelli. You may recall that this agency was hired to investigate Paul Murdaugh shortly before his murder. Some had even hoped that perhaps some alleged hidden cameras near the property might have inadvertently caught the murder. Unfortunately, it didn't. But on her website, you will find a link to a Post and Courier article about her investigation of Paul Murdaugh. In a podcast I made back on February 11th, I told you that Judge Price was being removed from this case and being replaced, as mentioned earlier, by Judge Morgan. In the next episode, we'll get to hear him in action at his first hearing since taking over this case. Unfortunately, it was not televised, so you'll have to settle for my reading from it. First impressions of Judge Morgan, not bad. What I was really impressed with was his familiarity with the case. I've seen many a judge, even judges who've been working with the case for a while, approach a new hearing needing reminded of every little aspect of the case before them. Judge Morgan did not. He was up to speed on the motions they were going to consider at this particular hearing and many more details of this case. I realized while listening to it, however, that I was not quite as up to speed as I thought. As I was recording the transcript, I wanted to know more and found myself down a rabbit hole where I ended up printing the entire case index, as you see here in these 4 volumes. I especially focused on the transcripts because that's where we can get explanations on this mountain of motions. My next opinion is about Mark Moore. If you've forgotten who he is, he's a part of counsel for defense. He handles most of the load of all the attorneys in the defense team. Mark Moore is probably the best document preparer I've seen so far in this mess, including the Alex Murdaugh mess. Now, I don't mean content, because opinion alert here, he doesn't mind twisting facts to an astounding level in his motions and even in hearings. So when I compliment his motions, I'm talking about his style of writing. His motions are aesthetically pleasing, organized, if not a little wordy, and rarely have a typo or spelling mistake. Now, in person, I've seen him in action, and I cannot put the man and these well-written motions together in my mind as the same person. Here he is in action on the Russell Lafitte case.
Okay.
So
So perhaps I'll let Mr. Waters speak about scheduling. I'm certainly going to ask the court that it not schedule this case until we get a decision on the appeal bond issue. I will tell Your Honor that I've spent no time preparing for a state trial because I spent all my time on this case preparing to deal with his federal issues, to deal with his motion for a new trial, to deal with the sentencing, and now deal with the appeal. And Mr. Waters and I have talked about that, and perhaps I think we're going to jointly propose another status conference with Your Honor after the Fourth Circuit decides this appeal bond issue. That's what I hope we're going to jointly propose. I also am going to need several months to prepare for a trial if I'm expected to try this case. This case is...
Stall. It's often obvious to me who defense is just by the stall tactics and the sheer number of motions and the number of pages per motion. I'll bet when he types, you can hear a cash register with the clicks of the keystrokes of his keyboard. But now I've wandered way off topic, so getting back to this hearing, Mark Moore goes first. Like I said, I was recording it at first, since, as I mentioned, it wasn't televised. But after over 40 minutes, and it was still Mark Moore talking, I grew weary of being Mark Moore. I also found a lot of his accusations unsettling, as I knew they were incorrect based on files I've read from this case. Now, defense has made quite a few accusations and seems to be spending most, if not all of their attention attacking not the plaintiffs as in most cases, because in this case, the plaintiffs are the grieving family of Mallory Beach. Now, that's not going to reflect well on anyone to attack these people. So they can't do that. So instead, they attack the only thing they can, the plaintiffs' attorneys. This has been their entire defense from the beginning, and that's what they're doing here. He went all the way back to Genesis on this case, since it's a new judge. He hashed out all of those accusations, like I said, for over 40 minutes of me recording. I had such ick by then, because once Mr. Tinsley was able to speak, the lies were laid bare. So it's really a waste of time to start off by listening to all of that, because it takes us to the land of make-believe, and then we have to come back to reality. Speaking of which, this is what this new case actually does. It brings us back from the land of make-believe to the land of reality. Greg Parker has been denying these allegations for years. He spent nearly 3 years lying about what he was doing, and who knows how many hundreds of thousands of dollars, if not millions, he has spent perpetuating those lies, only to end up not paying someone a few $1,000s, someone that he was supposed to pay, that would have helped him keep it all covered up. What do I mean? Let's look at this complaint and summons. We talked about this in the last podcast about Will Folks, that a case starts with a summons and a complaint. These hold the basic information for the allegations of the case. They also hold the charges or the causes of action. Now, defense responds with an answer, or sometimes a motion to dismiss, and then an answer. Or it could get dismissed. They have 30 days to respond, so I'm still waiting for that. But this complaint tells us that Inquiry Agency, the plaintiff, operates in Charleston. The defendant law firm is based in Ohio, but is represented by its agent, Jason DeCruz, in the state of South Carolina. If you didn't watch my earlier podcasts about this case, Jason DeCruz served as attorney to Greg Parker and was the one who's alleged to have breached the contract between Jason, the firm, and Inquiry Agency, leading to this suit. This contract was entered into on February the 8th, 2021, almost 4 months to the day before Paul and Maggie were murdered. Inquiry Agency was hired to investigate Paul Murdaugh, as I mentioned earlier, and also his family, in order to gain information that was to be used in a public relations campaign to sway public opinion in favor of Greg Parker and Parker's Kitchens, because they were being sued in the wrongful death of Mallory Beach, or what most of us refer to as the boat crash case. This case even overlapped with the Stephen Smith case, with Inquiry Agency being instructed to try to find proof that Buster Murdaugh was gay to help them pin the murder on him. So basically, it was a no-holds-barred investigation. Now, an important point to note is that there have been subpoenas and motions to quash subpoenas since early on in this case, and one of the claims by defense is that what Sarah Capelli and inquiry agency were doing falls under attorney work product and is therefore privileged. This was their reason for refusing to comply with the subpoena. But just because it's your lawyer that's doing your shady work doesn't make it attorney work product. This was not legal work being carried out. And we see this in point 7, where they outright say the investigation of Paul Murdaugh is in no way protected by the attorney-client privilege, as the investigation of Paul Murdaugh and the public relations campaign were not conducted to give legal advice, but instead was a shadow campaign used to sway public opinion. Now we have the first smoking gun right here, because this is what Renee Beach's case has been all along, that this was a public relations campaign to sway public opinion, and Parker has denied this, and his lawyers have denied this, but right here, the very agency who was hired by them to collect that information for the smear campaign just admitted to it. Next, we have the biggest smoking gun of all. It says, additionally, all or nearly all of the investigation materials were shared with third parties, including, but not limited to, Wes Donahue and his companies and reporters Vicky Ward and Greg Roman. Again, those names may sound familiar to you if you listen to my first podcast. I will be expanding on those people in future episodes. But basically, there it is right there. Proof of how this information was leaked and to whom. Again, this is what Renee Beach's case has been claiming all this time, and again, what Greg Parker and company have been denying, and what his attorneys have built this mountain of motions saying, tying up the courts, hurling insults and accusations against fellow attorneys and judges. But right here, this complaint confirms that Parker and his co-conspirators gave the information dug up by Sarah Capelli to third parties for a documentary and for Greg Roman. Now the kicker to that is they've not only been denying it, but as I said, a big part of their fight has been fighting subpoenas that were put in place to gather evidence. And they've done this by saying that this was attorney work product and privileged and could not be collected. But how can it be that the courts were denied access, but this information was willingly handed over to third-party documentary writers, producers, reporters, Wes Donahue, the self-proclaimed knife fighter of the Lawrence Group, and we're going to get into him and these other people later, as I said, and this blogger, Greg Roman, who also was affiliated with this documentary. Now, how is this information too privileged to supply to the court in spite of a subpoena, but it was just fine to pass it around to people who are putting it right out into the world? This should clear up the decision on that motion. They've also been trying to deny the relationship with this Greg Roman, but this suit hurts that claim as well. It was already going to be really hard to do that because Parker has already admitted to the Wall Street Journal and to Dateline that they were affiliated. Now, defense has denied this using their twisty words, but this is going to make it harder to deny, and these are the huge points about the impact of this new case. Now, back to these subpoenas. In point 10, it says that the inquiry agency was told by Baker Hostetler and its agents that it should not comply with the subpoena under any circumstances, and that it needed to meet with Greg Parker, his counsel, and with Jason DeCruz of Baker Hostetler about the subpoenas, and it needed to retain counsel to object to the subpoena. So Greg Parker, his attorney Jason DeCruz, and DeCruz's firm were advising inquiry agency not to comply with these court-ordered subpoenas. But let me back up. Using the word advising makes it sound official, so I'm going to take that word out and use the word from this document. They told them not to comply. So they were not serving as their counsel in this matter, but they were telling them not to comply. Now this leaves inquiry agency in a bad spot. They'd been served these subpoenas. They were being told to do one thing, but while they were spending hours with attorneys, as they were told to do by Hostetler through Jason DeCruz, they did not really want to file objections to the subpoenas. So in the background, they were compiling the requested documents. And even though they're not a law firm, even they were aware that this information was not privileged because it was not material for attorney-client matters. They knew what it was. They knew it was information for a public relations smear campaign, just as Renee Beach has maintained from the beginning. And as I said, we'll get into more information about this Wes Donahue, where we'll learn that this is exactly what he does in his business. As I showed you, I've printed out the whole case, and I've been deep diving it, so this is only part 1 of this update with more to follow, and I'll go into each of these people or agencies. But Wes Donahue of Lauren's Group, and now of Push Digital, he was mentioned and described as a knife fighter. Now, I always thought this was a strange description. I wondered where it came from. But as I was going through and printing these, in an earlier transcript, I found out where that came from. He literally called himself that on his website. Did you catch that? He called himself a knife fighter on his business website. Now, this isn't an opinion alert. This is a cheesy alert. Calling yourself a knife fighter on your business website. I had to reread that. But what he meant is that he does stuff like this. Smear campaigns. Now in point 13, because Baker Hostetler and Jason DeCruz told them to get legal counsel, Inquiry Agency ended up incurring thousands of dollars in legal costs. Now let's remember, they were hired by Baker Hostetler to do this work, then told to hire counsel to follow their instructions not to honor the subpoena. Now point 14 is a clip from this contract. It says, client agrees to restrict the dissemination of said findings only to third parties who have a legitimate need to know and or authorized by law. Now, doesn't that cover a subpoena issued from a court? What else does authorized by law mean? But here's an important bit. Inquiry Agency is held harmless from damages, losses, cost or expenses, including attorney fees, suffered or incurred in connection with arising out of claims based on investigative findings provided to the client. So this contract clearly states that any expenses associated that come out of this investigation would not be the responsibility of Inquiry Agency. Now this is the third smoking gun, because as we've learned, they were instructed to consult an attorney. And though Baker Hostetler told them in the contract that they would not be responsible for anything like this, what happens when they submit a bill? It doesn't get paid. Now Baker Hostetler, as mentioned at the beginning, has been paying hundreds of thousands of dollars. It could have passed into the millions by now. This case has been going on for a couple years now, but they were not interested in paying a few $1,000s to help Inquiry Agency recoup legal fees from following their own directions. So as we see in point 16, they say they should be able to recover these costs and expenses under the theory of unjust enrichment, because they were acting at the direction of Jason DeCruz, an agent of Baker Hostetler. Now under the first cause of action, which is breach of contract, we see in 19 that this contract between them was breached by their failing to pay the reasonable invoice of Inquiry Agency. Glancing back to page 3, point 5 says that this court has jurisdiction over this matter as the claim does not exceed $75,000. So we're not talking about a huge settlement they're looking for. It's less than $75,000. So they weren't asking for an outrageous amount of money. But even still, point 20, Inquiry Agency has repeatedly asked Baker Hostetler. Now remember, this is a huge firm. It has branches all over the United States. Huge firm. Asked for them to pay for the expenses that arose because of their instructions, but they have repeatedly refused to pay those expenses. All they had to do was pay these expenses. This kind of money's nothing to them, but they wouldn't do it. This huge law firm with so much on the line hired by millionaire Greg Parker, also so much on the line. And they wouldn't pay it. But you know what? I'm honestly glad they didn't do that, so that this could come out. Things have a way sometimes of working out as they should. So in 21, for this cause of action, a breach of contract, they feel the plaintiff is entitled to a judgment for damages, attorney's fees, costs associated with this action, and for pre-judgment interest. Now for the second cause of action, we have unjust enrichment. And that was mentioned before, but let's get into what this means. Unjust enrichment is an equitable doctrine. It requires that one party make restitution to another party if that first party has been enriched at the second party's expense. Now this applies when there's no adequate legal remedy. And that's why sometimes unjust enrichment may be referred to as quasi-contract or implied contract, and its purpose is to provide equitable relief in the absence of an enforceable contract. So this contract, they had a contract. However, the wording just says that inquiry agency is held harmless from damages, loss, cost, or expenses, including attorney's fees suffered or incurred in connection or arising out of claims based on their investigative findings. It does not say Baker Hostetler will pay your legal fees. So here's where we have quasi-contract or implied contract, not an exact contract saying we ourselves are paying your legal fees. So, although this theory is nationwide, the elements do vary a little from jurisdiction to jurisdiction, but generally, what has to happen for it to be unjust enrichment is 1, the defendant has to have been enriched, 2, at the plaintiff's expense. And it would be inequitable to allow the defendant to retain this enrichment when the plaintiff is seeking to recover it. So there has to be a relationship between the enrichment and the impoverishment, or the defendant must have caused the loss to the plaintiff. There can't be a justification involved, such as in this case, how do they justify not paying these fees? There is no justification for it. So this is the theory that this case is based on, this unjust enrichment. Now in these cases, the burden of proof does fall to the plaintiff, but if the court finds in their favor there is restitution, the plaintiff should be made whole. And we see this description in 24. The plaintiff refused to comply with this subpoena, and this caused benefit to the defendant. The defendant did realize value from this benefit. The value was that itself was protected, its client was protected, by keeping this information from this public relations campaign away from the court and the plaintiff. Now this has incurred costs and time to the plaintiff, so while the defendant benefited, the plaintiff lost. And as it says, the defendant should have known the plaintiff expected to be paid. They were billing them repeatedly. So it is inequitable, or basically unfair, that the defendant retain this benefit at the cost to the plaintiff. So for this, they're entitled to judgment for damages, attorney's fees, and again, costs associated with this action. And finally, the third and last cause of action is violation of South Carolina's Unfair Trade Practices Act. We see that in 30, they refuse to compensate the plaintiff for her time and expense. 31, the plaintiff has suffered actual ascertainable damages. And again, they say the plaintiff is entitled to an award of actual damages. It mentions treble damages. Now this came up in the case specifically when Eric Bland was making his case to the receivers of Alex Murdaugh's asset money. He mentioned that under this Unfair Trade Practices Act, that victims are entitled to treble damages or triple the amount. It's not always granted, but it can be asked for according to this act. And also attorney's fees and costs. And so they asked the court for a jury trial and the relief that the court might deem just and proper. So as far as I can see, this suit pretty much destroys the defense in the conspiracy outrage claim. Now, I'm currently going through these binders, gleaning more information than I previously had sorted through. So for those of you who might want more details about this case, who all of these people are, and what got us to where we are here today, keep on the lookout for those here. I've also learned some new things in this case. Something called bots. Now, these bots are set up on social media to make or destroy people's reputations. I've heard them talked about, but I never really fully investigated them to see what they were about. Bots and troll farms, these things are very much alive, and they make huge impacts on things, anywhere from celebrity gossip, singers, politicians, athletes, and even the royal family divide. People are being influenced, often, I would say more often than not, by bots and troll farms. What a world we live in 2024. Till next time, this is Cassidy O'Connell saying stay well and stay tuned.